Is it smart to get a Guardian Ad Litem on my case? Hi, I'm Zachary C. Ashby at Pacific Northwest Family Law. Oftentimes in family law, we come up with the question of whether or not to get a Guardian Ad Litem or GAL. Now, a Guardian Ad Litem is someone appointed by the court in custody disputes. It's when oftentimes parents, either they're making accusations against one another, or there's something that prevents them from reaching an agreement on what the parenting plan should be. And the court believes oftentimes that it would be helpful if there was a third party to go and investigate what's really going on. And that is a role of a guardian ad litem. Guardian ad litem will talk to witnesses, look at documents such as school attendance records, sometimes medical records. He or she will talk to doctors, teachers, friends sometimes, in addition to interviewing each parent and the child in the parent's home. They'll then write a report and oftentimes make recommendations about the parenting plan arrangement. That might sound pretty good, but there are certain things to keep in mind, pros and cons at getting a guardian ad litem involved. First of all, it can often entrench positions of an unreasonable parent, especially if the unreasonable parent has the ability to maybe sway the guardian ad litem in their favor. There can be lots of reasons why this might happen. It might just be the magnetic personality of that parent who's able to maybe convince them or put on a good front so that the guardian ad litem is very favorable to their position. On the other hand, the guardian ad litem can break down positions of entrenched parents. One, because they'll be doing a report, and if they discover evidence that indicates that there's a better parenting plan, that there's a problem with having a child in the parent's home, or that both parents are equally fit, that can also help break people out of the positions that they're in. Now, there's some other things to realize when working with guardian ad litems. Not all guardian ad litems have the same background or training. Some of them will only have maybe an associate's degree, and some of them may have master's or a doctorates in the areas that would be applicable to their work as a guardian ad litem, such as childhood development or education, or even psychiatry, things in that nature that would enable them to make good judgments. And sometimes attorneys will serve as guardians ad litem, attorneys who have worked in family law, who have some experience there. And there's a range of benefits and dangers, of course, with that background. People with less education or less training will produce different results than people with more training, and the court will give it different weight depending on what they come up with. The many factors involved in child custody are really too many to give blanket advice. And this is why it's important to talk to an attorney, talk to your attorney about your case and what's going on and what guardian ad litems are available and who might the court appoint, so that you can see whether getting this special investigating person will help or could backfire on your case. When you're considering doing this, you really need some expert advice from an attorney who's advocating for you. And it's something that we advise our clients on all the time. So if you have any questions, please comment below, like and subscribe to our channel. Call us if you need anything more at 509-866-4111. Thank you.